Madam Chief Justice, Justices, I'll take you to the index of the condensed book, Mr. Smith, and after the table of contents on the third page begins the outline of oral argument that I prepared for today's purposes. My intention is to take you first to the facts of the case. In Mr. Smith's respectful submission, the Crown's position largely ignores the factual findings made by the trial judge below, and of necessity must ignore those factual findings in order to prevail. I'll then discuss the standing issue and then move on to Section 7, Section 1, and the issue of remedy. With respect to the facts, and they are unchallenged in this court, the trial judge found certain key things. The first is that the medicinal compounds in cannabis are contained in resin glands that are grown on the plant. The plant material itself is inert. The government's position would have you conflate dried marijuana as a compound, as a substance, with the derivative compounds and say that they're somehow different substances. That dried marijuana is different from edible products, is different from topical products, is different even from Sativex, which is a conventional derivative product of cannabis. The difficulty, of course, is that the findings of fact run contrary to that position. The medicinal compounds are contained in the resin glands. They're not contained in the plant. And it is those compounds that provide the therapeutic effect. Whether those compounds are smoked, whether those compounds are orally ingested, whether those compounds are sprayed under the tongue by a transmucosal mechanism such as Sativex, it's the compounds that provide the therapeutic benefit. It is not the dried plant material, and that fact is unchallenged. The trial judge also found that the compounds can be ingested in a variety of ways. They can be smoked or inhaled using a vaporizer if one can avail themselves of that particular product. Smoking increases risk. Smoking is indeed the key risk associated with the consumption of cannabis, as identified both by the Crown, by Health Canada, by the Crown's witness, by the trial judge, and by judicial decisions in this area, as pointed out by one of the interveners. Smoking has repeatedly been described as the risk, and I can even take you to the Crown's condensed book of authorities at tab 8. Sorry, not 8. At tabs 4 and 5. Well, the very last page of each tab sets out the issue of smoking. And it's very clear under issue 14 at tab 4, concerns and response. Smoking marijuana for medical purposes in a public setting, thereby potentially exposing others to the drug's effects, is unacceptable. Patients are therefore expected to use common sense. At tab 5, very last page again, there's a description of physicians' opinions with respect to the use of cannabis for medical purposes. Physicians generally express concerns that marijuana is most often ingested by smoking and encourage development of alternative forms and routes of administration. So smoking, as Dr. Pate described and as the trial judge accepted, inhalation, is a method of ingesting the medicinal compounds that has utility. It produces therapeutic benefit quickly. That therapeutic benefit happens fast, tapers off very quickly. It's good for acute conditions. It's good for breakthrough pain, for example. He described it as good for using if you feel a migraine coming on. You would smoke, you would get the medicinal effects quickly, they would taper off quickly. Oral ingestion does not provide or produce the same potential harms as smoking. It is good, as Dr. Pate testified and as the trial judge accepted, for things like chronic conditions, glaucoma, chronic pain, conditions where you need to have a systemic load of the medicinal compounds at all times in order to deal with your medical conditions. And so you eat it, it takes a little bit longer to take effect, but the effects last for hours. And so you're not forced into a situation where you're repeatedly consuming the medicine by way of smoking all day long, or as Ms. Herman testified, waking up in the middle of the night in pain after 2 hours and then having to smoke fall back asleep for another couple of hours, wake up again in pain, smoke again, and you go through this cycle of constantly ingesting the medicine by way of smoking, when you can orally ingest it, achieve the benefits over a longer term. Those are unchallenged facts. There is a difference in effectiveness. That is a factual issue that was found that the Crown can't avoid, and therefore retreats very quickly from the findings of fact to dwell in the area of subjective preference. And I'll have more to say about that later.
What do you say about his argument that it hasn't been clinically tested the way dried marijuana has, and so even if there are dangers to smoking, we don't know what the dangers are in having other forms of marijuana available? Three things.
Firstly, one of the declarations that's required by the marijuana medical access regulations before a patient is granted an authorization to possess dried marijuana is that the physician and the patient understand that there's been no regulatory approval given and that there hasn't been a great deal of scientific study about dried marijuana generally. So I think that detracts from the point of the Crown that, well, we know dried marijuana is a known quantity. We know a bit more about it. Secondly, the Information for Healthcare Practitioners book assembled by Dr. Abramovich and put into evidence before the trial judge, from which he made findings of fact, details the other methods of ingesting cannabis and is heavily referenced with citations to scientific authority. Let's remember, what's providing the therapeutic benefit are the compounds. The mode of ingestion changes the effectiveness and the risk profile of how you take those compounds. But the compounds aren't different. The compounds are the same. And thirdly, I would say this, with respect to Sativex, which is a conventional treatment made, as the government pointed out just moments ago, from a whole plant extract, there have been clinical studies done. And that's how it obtained regulatory approval. It's not as if cannabis is not a known quantity. We know a tremendous amount about it. The trial judge made findings of fact that these methods of ingesting the medicine were as safe or safer than smoking it. The witnesses testified to no harms arising as a result of using these particular modes of ingestion. And all of this was confirmed by and conceded to by the Crown's witness at trial, and was further confirmed by the information that Health Canada assembled for provision to doctors before they sign off on someone's access to dried marijuana. And so I say the suggestion that somehow there are greater dangers associated with oral ingestion or topical application of cannabinoids is belied by the facts that were found below. Those aren't the facts that are before you. The facts are that these products are safe, as safe or safer than conventional over-the-counter, some conventional over-the-counter, and prescription medicines. We know they're safe. There aren't any risks, and none were shown before the trial judge, and his findings of fact amply support that. There is a further benefit from either oral ingestion or topical application is found, and that's the delivery of the medicine directly to the site of pathogenicity. This is a principle that Dr. Pate testified was not unique to cannabis. This is for all medicines. It's the reason why when you have a rash, you put a cream on the rash instead of taking a pill to deal with the rash. You certainly can do both, but wouldn't you rather use less on the site that needs the medicine as opposed to taking more and developing a systemic load? The patient witnesses themselves all benefited from the use of these medicinal cannabis products, and they did so in forms other than smoking or vaporizing the dried plant matter, including the particular products from which Mr. Smith stood charged at trial below. And the trial judge found, the Court of Appeal agreed, that while patients can possess dried marijuana lawfully pursuant to the MMARs, and I believe that this addresses the question that you asked the government, Justice Cromwell, about Mr. Justice Jason's dissent, they commit crimes punishable by severe deprivations of liberty when they extract the medicinal compounds from the dried plant matter and discard the dried plant matter. That is in my respectful submission, clear from the language of the Controlled Drugs and Substances Act. And my friend says and urges this court to apply common sense in its line drawing exercise. Mr. Smith's position is that the court should apply the charter and not common sense to this exercise, and should look at what the Controlled Drugs and Substances Act prohibits.
I hope we don't have to choose.
Fortunately, in this case, they line up. The Controlled Drugs and Substances Act prevents production, which includes a broad definition of manufacturing, deriving products. It's illegal to produce THC oil. Mr. Smith was charged with possessing THC for the purpose of trafficking because he was making oil an extracted product. That's not lawful. It's not lawful for Mr. Smith to do it. It's not lawful for a patient to do it either. They can be criminally charged. It's not lawful for them to possess those products either. They're granted an authorization to possess dried marijuana and dried marijuana alone. I should also am constrained to point out that my friend, I think, was in error when he suggested that the MMARs have nothing to do with distribution of marijuana. A designated producer is perfectly entitled to produce marijuana plants and to distribute dried marijuana to up to 2 patients that have designated that producer to produce marijuana for them. That's trafficking. That's distribution of marijuana. You're even entitled, as a result of the changes the government made in 2005 to the regulatory scheme, to receive compensation from your patients for engaging in that activity. That is selling marijuana, dried marijuana, to patients. So the MMARs do authorize distribution. What they don't authorize is the production and distribution of anything other than dried marijuana. And that's why we're before you today. It's that restriction to dried marijuana alone that gives rise to the constitutional problems identified. And that really brings me to the standing issue. And it is difficult to get around the Big M problem. My friend says, well, Mr. Smith didn't avail himself in any way of the regulatory scheme. He was operating completely outside that scheme. Anyone charged with a criminal offense is operating outside the regulatory scheme. That's a basic principle. What you're doing is unlawful, and you're charged with a criminal offense. Now, Mr. Smith didn't challenge the MMARs. He challenged the Controlled Drugs and Substances Act, under which he was charged. The focus of the argument was on the exemption scheme, because it was the exemption scheme that dealt with access to dried marijuana for medical purposes. But he wasn't charged with an offense under the MMARs. There is no offense provision under the MMARs. He was charged with a criminal offense, and he raised the charter as a defense to those charges. In much the same way that Big M Drug Mart, charged with an offense, was able to raise the unconstitutionality pursuant to Section 2 of the charter as to other people. Corporations don't hold religious beliefs. But yet, Big M was able to say, this is an unconstitutional law for which this corporation stands charged with violating, and it's unconstitutional not as to Big M. Big M doesn't hold a religious belief. It's a company. It's unconstitutional as to others that do hold religious beliefs, or atheists who hold no religious beliefs.
Does it matter that the constitutional fix, if I can use that word, that the judge gave as a remedy, leaves the scheme intact as regards Mr. Smith?
It matters not on the issue of standing. It does matter, I think, when considering what the Crown has said about seeking a new trial. Because what the Crown has said is, well, after the judge made his ruling, we felt that we were unable to convict Mr. Smith. And yet in this court, I think what he said was, well, how do you instruct a jury? How do you make those arguments? Well, in this court, he's made the arguments. He said he's operating entirely out of the side of the regulatory scheme. And presumably that would have been the argument at trial. Well, yes, the law has been stricken down as a result of its unconstitutional effects on patients, Mr. Smith isn't that patient. Mr. Smith is a producer operating completely outside the regulatory scheme, and therefore he should be convicted for the offense. That's the argument. The Crown's decision was to call no evidence and to have Mr. Smith acquitted. And so I was going to say this at the end of my submissions, but I'll say it now. Under no circumstances, in my respectful submission, should this court send Mr. Smith back down to be retried on these charges, even if he doesn't prevail on the charter arguments. It was the Crown's decision not to try him. It could have. It chose not to.
So I guess just for the purposes of the standing argument, we're getting into a pretty narrow distinction here in the sense that it boils down to saying that he had the right to make the arguments that he made and have them ruled on, but having got the remedy he had didn't affect his liability under the section.
It didn't in the sense that he was operating outside the regulatory scheme as it stood. Now, had the regulatory scheme been constitutional, in other words, had it...
I'm assuming that you get the remedy you got. Then there was nothing to stand in the way of being tried on the indictment.
The trial was scheduled, and 7 months after the charter voir dire, the Crown elected to call no evidence at the trial.
And that's the difference between this case and Big M, that after the constitutional ruling, there was no offense to try.
And I want to make this point very clearly. Had Mr. Smith, had the unconstitutional and impugned restriction not been in place, and Mr. Smith been, or others been permitted to have access to non-dried forms of medical cannabis, Mr. Smith could have been designated by, for example, the two patients, Ms. Quinn and Ms. Herman, who received authorizations to possess dried marijuana, and he could have been designated to produce the products that he was producing for the club for that. Would that, if he had operated outside of that and produced for other people, it could have given rise to a further challenge based on the principles in Svekopoulos and Hitzig, having to do with the ratio between patients and producers? That's a different case. We'd be arguing a different case. But had the impugned restriction not been in place, there would have been a way to operate within the regulatory scheme to produce these products for the patients that required them for their health. The reason that he had to operate outside the regulatory scheme is because of the impugned restriction. And I think that fully undermines my friend's position on standing. I would certainly also urge this court not to narrow the principle in Big M. I think the interveners had quite a bit to say about the issue of standing and the importance of being able to raise charter defenses to being charged with criminal offenses. And the narrowing of that would really take away from the fact that the charter is the supreme law of the land. It would in effect, allow prosecutorial discretion to be a substitute for the supremacy of the charter. The Crown could keep in place unconstitutional laws that violate the charter, and take away autonomy in arbitrary, overbroad and grossly disproportionate ways simply by not prosecuting the wrong people, or by realizing when someone brings a constitutional challenge, perhaps now's the time to stay the charges to avoid a decision on the charter merits of the issue. The arbiters of what the charter protects are the courts, not the discretion of Crown prosecutors. If, however, the court is inclined to accept my friend's position on standing, in terms of direct standing, Mr. Smith certainly urges that this case be considered a public interest case. This is a serious justiciable issue. As the government just pointed out, these regulations affect many, many people across the country. It is a case of nationwide importance. It is a case that has been thoroughly litigated both at trial and briefed at trial and in the courts of appeal and in this court. They meet the test for public interest standing. He is engaged with the issues, and the case has been brought before you in a reasonable and efficient manner. It would be unreasonable and inefficient to deny standing at this point simply to have a patient come forward and then challenge these regulations and return here some years hence. Now, in terms of the Section 7 threshold, my friend's argument is twofold. He says first that despite the clear liberty violation arising from the specter of imprisonment for persons that possess forms of marijuana other than dried marijuana, this case should not be considered on Section 7 grounds because there is no objective evidence in the record suggesting that these patients have anything other than a subjective preference for an illegal form of treatment over a lawful one. In order to make this argument, my friend has to essentially ignore the findings of fact of the trial judge, because those findings of fact run completely contrary to that position. The trial judge found as fact that there are differential effectiveness to different modes of ingestion, that there are risks attendant with smoking that are not present in the other forms of ingestion, and that the patients benefited from medically from these other modes of ingestion. In addition, in the record are documentary evidence from, in some cases, the physicians of the patients, and in particular, I'd say, with respect to Ms. Quinn, and I won't take you to the record, but it is in the appellant's record, Part 4, Volume 1 at page 159. There's a letter from her physician describing how Ms. Quinn is using a topical application of cannabinoids on her incision that she had post-mastectomy incision to help reduce swelling and allow the healing of that incision. And he says it works remarkably well. Also describes how she's ingesting orally cannabis products and how those products are assisting her. This is from her physician. He wasn't called at the stand, but the exhibit went in to evidence below, and it's part of the basis upon which the trial judge makes his findings of fact. In addition to that, as the Court of Appeal recognized and as the trial judge recognized, it's a bit of a red herring to say that there's no medical evidence or objective medical evidence. The Government of Canada issued two of the witnesses authorizations to possess dried marijuana on the basis of their physicians' declarations required in the regulatory scheme that conventional treatments have been tried or considered and were found to be medically inappropriate or ineffective. The physician's declaration that the patient should have access to dried marijuana. And in the case of Ms. Herman, the physician checking off a box on the application form that says the mode of ingestion ought to be oral ingestion. These are objective facts that are in the record that support the trial judge's findings of fact on these particular points. Further to that, as was pointed out during my friend's submissions, Dr. Abramovici, the Crown's expert, conceded essentially that Dr. Pate was right, that for acute conditions, inhalation would deliver the benefits quickly. For chronic conditions, oral ingestion would deliver the benefits over an extended period of time. That completely supports exactly what the patients described as their own individual experience with their own medical conditions, and was accepted, again, by the trial judge on facts that are not directly challenged in this court. Because I think my friend, in order to prevail, needs to have this court overlook some of those findings of fact, or at least minimize their relevance to the particular issues that are joined. Liberty and security of the person rights are concerned with individual autonomy and dignity. As was pointed out at the beginning of my friend's submissions by Justice Abell, I think, this court recently had the opportunity in Carter to discuss autonomy in the context of making medical decisions. And I'll take the court to the condensed book that I've provided at tab it's tab K. Sorry, it's tab M. And this would be back side of the second page, commencing at paragraph 64, where this court said directly that underlying both of these rights, that is the right to liberty and security of the person, is the concern for the protection of individual autonomy and dignity. Liberty protects the right to make fundamental personal choices, free from state interference, free from state interference. Security of the person encompasses a notion of personal autonomy involving control over one's bodily integrity, free from state interference. And it is engaged by state interference with an individual's physical or psychological integrity, including any state action that causes physical or serious psychological suffering. While liberty and security of the person are distinct interests, for the purpose of the appeal, they may be considered together. These are issues that are directly implicated by the impugned restriction. One needs to go no further than the testimony of Ms. Herman, who describes the impact on her quality of life resulting from the use of pharmaceutical substances, and the fact that, as the trial judge said, she got her life back. She repaired her relationship with her husband. She repaired her relationship with her children. She experienced a cessation of the kind of pain she was experiencing, the waking up in the middle of the night in pain, the inability to sleep, the acting like a zombie and being unable to participate in social events as a result of the use of the products that the MMARs make unlawful for her to possess or to produce. As a result of using those products, her psychological state of mind improved, her physical health improved. And the state here wants to interpose the criminal law between her and access to those medicines in a manner that is completely unrelated to her individual needs, her wants, her desires, and her dignity. Mr. Smith says that's absolutely inappropriate. That's a severe violation of both liberty and security of the person. This court went on to say in Carter, at paragraph 65, the trial judge concluded that the prohibition on assisted dying limited Ms. Taylor's Section 7 right to liberty and security of the person by interfering with fundamentally important and personal medical decision-making, imposing pain and psychological stress, and depriving her of control over her bodily integrity. I'll pause to say that's precisely what the effect of the MMAR's restriction is on persons like Ms. Quinn and Ms. Herman. They are suffering from serious medical conditions. They are finding relief from the medicinal compounds contained in cannabis. They have been granted by permission by the government of Canada to access those compounds. And what the MMARs say is you can only access those compounds in the form of dried marijuana. You can't use the products that are actually working for you. We want you essentially to smoke cannabis all day long or all night long. This, despite the fact, as I referenced earlier at my friend's condensed book, in the tab 4 at the last page, this despite the fact that in the RIAs accompanying the MMAR, what the government of Canada says is that smoking marijuana for medical purposes in a public setting, thereby exposing others to the drug's effects, is unacceptable. It's unacceptable, according to the government of Canada. So Ms. Herman, who wants to perhaps go watch her son play soccer, isn't supposed to smoke her medicine in a public setting. As a soccer coach, I can tell you that probably wouldn't go over very well. But the government's telling you it's unacceptable to use your medicine in public in the manner that it only allows you to use the medicine. Because if you turn the medicine into a capsule that you can then take before you go out into public, that's unlawful. You've produced an unlawful substance. You're in possession of an unlawful substance. You could be arrested, charged, convicted, and imprisoned for doing so. And my friend says, use common sense. Again, I would expect Crown to use common sense in determining whether or not to prosecute an individual in those circumstances. I would expect them to apply the test of whether or not it's in the public interest to prosecute a patient in those circumstances. It does not change the fact that that conduct is criminal conduct. And that imposes a severe psychological burden on people. People don't want to break the law. Sick people should not be told, well, we're going to use common sense in whether or not to prosecute you for breaking the law if we catch you in possession of these medicines. That's not an answer to the Charter. The Charter says an infringement of liberty or security of the person that deprives one of the fundamental choices that one is entitled to make about personal medical decisions violates Section 7 unless it's in accordance with the principles of fundamental justice. And on the findings of fact that were made below, applying the proper analysis, perhaps using inexact language, but applying the proper analysis at the end of the day, the trial judge and the Court of Appeal agreed that this restriction was arbitrary. And it was arbitrary because it produces effects that are inconsistent with the law's objectives. And I should move now.
Could I just stop you there for one moment? Mr. Riley also mentioned I think, 3 products that are legally available in the vaporization as alternatives to smoking. Was there evidence about that in relation to any of the patients?
There was. Some of the patients did vaporize from time to time. Vaporization, of course, still produces an exhalation, an odor. The use in public would presumably be unacceptable according to the Government of Canada. The patients had not experienced the use of Sativex. The 2 that qualified for authorizations to possess, their physicians had indicated and were required to declare that conventional treatments were medically inappropriate or ineffective. Sativex is a conventional treatment. It's gone through the Food and Drug approval process. I think it's a fair inference from that to say that the physicians didn't agree it was useful. And you did ask Justice Cromwell about what conditions Sativex was approved for. It's been issued a notice of compliance with conditions, and it's been approved for neuropathic pain associated with multiple sclerosis, and subsequent, I believe, to the decision at trial, was also approved for neuropathic pain associated with cancer. The difficulty, of course, is that think about Ms. Quinn. What's she doing? She's at one point describes, and I have this in my condensed book at tab D, second page, second full page, top of the page, 93. Ms. Quinn says, firstly, that she didn't want to smoke because she had a bad reaction to a pesticide-laden product that she had taken and got a lung infection. But then she says after her mastectomy, she didn't want to smoke because it made her cough. And she was worried about ripping her incisions open as a result of that coughing. And so what she did is she mostly rubbed the cannabis oil on the incisions to reduce swelling. THC is an anti-inflammatory, CBD is an anti-inflammatory. She would rub that on the incision to reduce the swelling. This is halfway down the page, 93 of tab D in the condensed book. You don't spray Sativex on incisions. It's not what you do. It's a submucosal spray. You spray it under your tongue. It has the same rapid absorption that inhalation does. That's one of the benefits of that mode of delivery. It gives you the effects very quickly, but it also tapers off quickly, just like smoking. And so it doesn't provide the same types of benefits. And certainly it's an alcohol extract. I think one can infer that you're not spraying alcohol extracts on sutures and incisions on your chest. That's just not the way the medicine is intended to be used, in addition to the fact that it's a notice of compliance with conditions that only relates to 2 particular and discrete areas of medical practice.
I want to bring you to remedy, but are you finished with the Section 7 argument?
I was going to move, I'm happy to discuss remedy now, Justice Abella, but I was going to make just a few more points about Section 7, because I think I've only gotten to the threshold of our liberty and security of the person implicated on the facts of the case. And I do want to say, I've said a bit about subjective versus objective evidence. I think that fails on the record. But I do want to talk a bit about arbitrariness, overbreadth, and gross disproportionality. And arbitrariness in Mr. Smith's submission is made out here in much the same way it was made out in Carter, in Morgenthaler, in Chiuli, and in PHS. We need to think about what the objective of the legislation is. And my friend urges this court to consider the objective as state control over drugs by means of a comprehensive legislative scheme. as I said in my factor, that's a conflation of the objective with the means that the state goes about in achieving that objective. The means are the comprehensive regulatory scheme. Those considerations are best left for Section 1, not for Section 7. What's the objective? Mr. Smith's submission is that the objective is the protection and health and safety of people that have been granted permission by the Government of Canada to have access to these medicinal compounds, not some sort of general protection of health and safety. You have to draw the objective, as this court said in Bedford, narrowly to avoid essentially swallowing up the analysis. But even if the objective is the protection of health and safety, when you have a restriction that actually creates a set of conditions in which patient health is harmed and they are denied access to more effective ways of taking medicinal compounds, also harming their health and causing risk to health, causing physical pain and physical suffering, that is arbitrariness. And I think the example of Ms. Herman's a good one. Ms. Herman testified that she would take her dried marijuana that she's lawfully entitled to possess, and she'd make a tea solution with it in the morning. So she'd crush up the dried marijuana. That's lawful. She'd put it into a tea strainer. That's lawful. She'd put the tea strainer into the tea with a little bit of milk, because the fat in milk will then solubilize with the resin glands, and you'll have an extraction process. Not legal. She's now produced THC in a weak oral solution, and then she would take the tea strainer out and set it off to the side because that's what you do. And what she's holding in her hand now is a weak oral solution of THC and CBD and other cannabinoids. She's produced that. She made it. She manufactured it. She derived it. Those are the words of the Controlled Drugs and Substances Act. She's possessing it. My friend says, well, there's no rules in the MMAR about how you use your cannabis substance. See, we say here in the RIAS statements to the MMPR, well, there's no rules about how you use your cannabis. No, there's no rules in the MMAR about how you use your cannabis. There is a rule in the Controlled Drugs and Substances Act that says it's unlawful to do what I've just described Ms. Herman as doing. And so she's perfectly fine holding that dried cannabis. She's not fine holding her medicinal tea out of it. And that is arbitrary. That, in my respectful submission, highlights the arbitrariness of these restrictions. And it does so in a way that is difficult to reconcile with the factual record. The compounds, my friend says, well, these things, these derivative products, they're untested, there's no clinical studies, they're untried, the safety profile's not known, on the one hand. But on the other hand, he's saying, but the government of Canada doesn't have any restrictions on patients making these substances, and they can consume them any way you want. There's a contradiction there. I mean, it's either an untested, untried substance that should be kept out of the hands of people to protect their safety, or it isn't. And if it isn't, doesn't that undo my friend's point entirely? If patients are really able to do whatever they want with their dried cannabis and ingest the compounds in any way they want, it completely undermines my friend's point about the line being drawn at dried marijuana, because we're worried about patient health if they consume these other products. Apparently, they're able to consume these other products any way they want to. That's a fundamental contradiction in my friend's position that there's no way to reconcile on the argument. I say further this, in terms of overbreadth, even if, as respect to some persons, the restriction does have some minimal rational connection to the objective of protecting health and safety, to the patients that testified at the trial, there is no rational connection. It captures their conduct, even though their conduct doesn't implicate the objectives. And that's what overbreadth is. That's what this court described overbreadth as in Carter, Bedford, and the other cases. And then I say gross disproportionality. The regulation is grossly disproportionate to those objectives because the effects on patients, as described by the witnesses and supported by the objective evidence of the experts is to harm health and to criminalize their conduct, to criminalize their choices of how to best treat their individual medical conditions. And it does so in a manner that does not further the goals of the legislative scheme. And I think this is where the comments of the trial judge about evidence related to diversion or harms of the products comes into play. We know that the law says you look at the objective, but when the burden has been met, when the rights claimant has met the burden of showing the infringement of liberty and of showing an infringement of security of the person and of showing that those infringements are not in accordance with the principles of fundamental justice, it's fair to say, where is the evidence that there is any benefit being derived? And I think it's more appropriately considered in Section 1, but that evidence didn't exist on the record. It wasn't there, and it undermines, and I think I'll conclude what I have to say about Section 7 there, and it undermines any position on Section 1 as well. And the evidence is, firstly, as the cases make clear, it's very difficult to, on Section 1 grounds, justify the overriding of Section 7 rights generally, particularly where the restrictions have been shown to intrude on liberty and security of the person in a way that's arbitrary or overbroad. There's a failure of connection there. There's a failure of rational connection there that is stark in the Section 7 analysis that really does the ability to justify it, at least in the facts of this case on Section 1, because there were no facts provided by the government in terms of the Section 1 analysis that would support that these products are dangerous, that patient health is harmed, that public safety is implicated, that diversion is occurring by the patients in particular. Those facts were just simply absent, and so there's no rational connection. In addition, the existence of other legislative schemes that would be applicable to the commercial production and sale of these products, but for their inclusion in the Controlled Drugs and Substances Act, demonstrates that the restriction is not minimally intrusive. And my friend talks a bit about a legislative lacuna and a threat to the rule of law in his discussions on remedy, and says, well, if the MMARs are stricken down, or if this restriction is stricken down, there's going to be this vacuum. The remedy that, coming to remedy, Justice Isabella, the remedy that Mr. Smith seeks is a reading in of an exemption from the Controlled Drugs and Substances Act. At the end of the day, the problem is that the government is treating medical cannabis in the same way that it treats recreational cannabis, what it calls a drug of abuse. People that use cannabis for medical purposes are not abusing it. They are using it on the recommendation of their physician. That is not abuse. That is legitimate use. It is a very distinct situation. As this court recognized in Malma Levine, there's a very stark difference between recreational and medical. And yet, the medical production of these substances, the medical distribution of these substances, the medical consumption and possession of these substances is prohibited, generally speaking, by the criminal law with a narrow exemption drawn by the MMARs. That's the difficulty.
I'm sorry. How is your remedy different than the trial judge going through and taking out dried from the regulation?
And it was a thorny issue before the trial judge, because the trial judge was attempting to provide an effective remedy to patients, principally in the first instance. And that's why the trial judge did not suspend the declaration of invalidity that he made as it related to patients, but did suspend it as it related to producers, to allow the government to step in and regulate. And what came about as we're working through the regulatory scheme is that striking the word dried out of the MMAR left in place the definition of marijuana. Marijuana in the MMARs is specific to cannabis marijuana as defined in Schedule 2, sub 1, sub 2. It means the plant. It doesn't mean resin. It doesn't mean THC. It doesn't mean the cannabinoids. It just means the plant. And so really the remedy, without turning it into meaning all of Schedule II substances, would have been an ineffective remedy, because it would have just left patients in the same position. They could produce the plant, they could possess the plant, but the minute they turned it into resin, even if they just tapped the flowers into their hands and were left with a small bit of the medicinal compounds in their hands, would have still been unlawful. Extracting it into oil and then having a solution of THC and the other cannabinoids would have remained unlawful. And that's why the trial judge redefined it to read to Section 2. The difficulty with that remedy sitting here today is that the MMARs don't exist anymore. The MMARs were repealed by operation of the MMPR. As referenced in one of the interveners' factums, there is ongoing litigation. There has been an injunction granted preserving, for some people, aspects of the MMAR regime. So in a limited sense, the MMARs live on by way of constitutional exemption. But as a regulatory scheme, it doesn't exist anymore. And so the difficulty in the trial judge's remedy and the difficulty in the Court of Appeals remedy is that it doesn't provide an effective and responsive remedy to the patients who require access to these other forms of the medicine. Because redefining a definition or striking down a restriction in a regulatory scheme that doesn't exist anymore leaves them still captured by the regulatory scheme that does exist, which has the exact same restriction in it, notwithstanding what my friend said from the regulatory impact analysis statement accompanying the MMPRs, and he took you to it, where he said, well, and it's at the last page of tab 7 of my friend's book, where he says, well, there's no restrictions on how dried marijuana is to be ingested or inhaled. The problem, of course, is that it's not the restriction in the, as I said, the MMPRs that's the problem. It's the restriction in the Controlled Drugs and Substances Act that is the problem. And that is why Mr. Smith comes before this court and says what's really required to follow the principle elucidated in Doucette-Boudreau, that charter remedies must be effective and responsive to the problems identified, is a read-in of an exemption to the Controlled Drugs and Substances Act. And that,
sorry, that brings me to the questions
Yes.
that I had. Was that put before the Court of Appeal, the argument about, it just strikes me that we're dealing now with a very different set of constitutional remedies.
it was not.
It was not put.
It was not put before the
So it's being
Court of
put
Appeal.
before us for the first time.
It is being put before you for the first time.
And the argument against just saying to the government, if we accept your argument that it's unconstitutional, find a way to make it constitutionally compliant within a period of time is?
I'd say here's the problem, and there are two problems. The first is that there's been no evidence put before this court or any court on why the Schachter criteria for suspending declarations of invalidity ought to apply in this case. There is no threat to the public safety. There is no threat to the rule of law. This is not a case of where you strike down a statute, all of a sudden no one will have the benefit of that statute. In fact, exempting medical cannabis from the Controlled Drugs and Substances Act will automatically, by operation of law, put medical cannabis into the natural health product regulation. The natural health product regulation governs the commercial production, marketing, and sale of medicinal plant and plant-based products.
How do you define medical exemption? You simply say at paragraph 195, you want us to read in a medical exemption. One person's medicine is another person's poison. What, isn't there not going to be problems just saying anything that you think is medical is going to be okay? One would think there'd have to be more detail provided, unless we want simply everybody to self-medicate.
Mr. Smith at trial took no issue with the requirement that a physician be a gatekeeper in the MMAR regime. It is reasonable for this court, if it reads a medical exemption into the Controlled Drugs and Substances Act, to say that that has to truly be medical. And medical could be defined by reference to the approval of a physician. And physicians, of course, are able to prescribe all manner of substances, potentially including cannabis, under Section 53 of the Narcotic Control Regulation.
Isn't this very conversation a reason for us not to wade in? Reading in is usually something we do when the circumstances are so clear about what the effect would be of reading in, and that the government really doesn't have any range of options to think about. Here, it's a new remedy that's being proposed for the first time before this court, without any argument or discussion about the utility, the precision. I see your point about the fact that they've had 3 years, effectively, since the decision was made. But doesn't that argue for less time than the year given by the Court of Appeal, rather than for reading in?
I'd say two things in response, Justice Abella. First, I would say the government's had more than 3 years to come up with a constitutional scheme. On this particular point, they've had 3 years. On the issue of the constitutionality of the medical exemption scheme generally, this issue has been litigated for the last 15 years. It's resulted in no less than 3 Court of Appeal decisions finding the regulatory scheme to be unduly restrictive, 1 decision in the BC Supreme Court, which proceeded by way of direct leave application to this court that was denied, finding the regulatory scheme to be insufficient on charter grounds. My friend has described the government's responses to those declarations of invalidity as robust. With the greatest respect to my friend's position, I think that the history that I provided in my remedies section tells a different story. The response has been anything but robust, and I'll give you one stark example. In the case called Svekopoulos, which was ultimately decided in the Federal Court of Appeal, a court of national impact, which I think runs contrary to my friend's point that this court is the first to deal with this case and have it have a national impact. Federal Court of Appeal did have national impact. But the case called Svekopoulos, one producer and about 15 patients challenged the 1-to-1 ratio between producer and patient that was contained in the MMARs. That restriction was found to violate the Charter of Rights and Freedoms as arbitrary and unduly restrictive. Now, keep in mind, this is 1 producer and 15 patients. It's a factual matrix of that case. The government's response to that was to amend the regulatory scheme. My friend calls it a robust response. They made it 1 producer and 2 patients. In my respectful submission, it's not even responsive to the case that prompted the response. And so there's been 15 years of opportunity. And what keeps happening, what we keep coming back to is that medical production, medical delivery, medical possession remains a criminal offense. And that puts patients at significant jeopardy of their liberty and their security of the person. It interposes the state in between them and their medical choices. Mr. Smith says that's unacceptable. Mr. Smith says the only way to effectively respond to that is to take medical cannabis out of the Controlled Drugs and Substances Act. Immediately it becomes a natural health product. And so the commercial aspects that my friend is concerned about, the commercial marketing, the commercial production, the commercial sale, remain regulated behavior. The Natural Health Product Regulation contains non-criminal, non-CDSA offense provisions. The government can continue to manage the commercial aspects of this endeavor. However, what the Natural Health Product Regulation does not do is criminalize individual patient conduct. And it does not then interfere with their liberty and their security of person in a way that using the criminal law, the heavy hand of the criminal law, does. And that's why, in my respectful submission, the read-in is the appropriate remedy. Should also say this. Proving intent, medical intent or other intent, is not a concept foreign to law. In fact, the Controlled Drugs and Substances Act, as a result of the 2012 amendments brought about by the Safe Streets and Communities Act, put very precisely into the production offense for producing marijuana plants between 6 and 200, a requirement that in order for the mandatory minimum sentences to apply, the Crown would need to prove beyond a reasonable doubt that the production was for the purposes of trafficking. That's an intention. So it's not unknown in the law to have intent to be part of the prosecution's case in chief. Indeed, the very offense for which Mr. Smith stood charged was possession for the purpose of trafficking. And in order to convict him, the Crown would have had to prove beyond a reasonable doubt that he possessed these products for the purpose of trafficking them. Now, we admitted that, obviously, in this particular case. But in terms of reading in a medical exemption, if the Crown and the prosecutorial authority, after a case comes to it from the law enforcement authority, reviews the facts and sees that in the ordinary course of investigation of marijuana offenses, someone is trafficking marijuana and there's no indicia of medical need whatsoever, that person's going to be convicted. That's the way the system works. That's the way the criminal justice system works. It's not an impediment to that to say you can't convict a patient, particularly a patient, of these offenses if the patient is using the products for medical purposes. And that is the way that we solve the thorny problems that have been plaguing patients for 15 years or more and plaguing the courts for that same span of time. At some point, the endless cycle of litigation on this issue needs to cease, and there needs to be a clear line of demarcation between what conduct the state is entitled to make criminal and what conduct the state is not entitled to criminalize. We know that recreational cannabis, as a result of Malma Levine, we know that the state is entitled to criminalize for recreational purposes. But as this court said, it's a very different thing indeed when the cannabis is intended for medical purposes. And we, in my respectful submission, that's a distinction that this court needs to drive home and make clear so that the courts understand what the law is, so that the state understands where its powers are circumscribed, and so the patients can understand that they're free from the specter of criminality for their medical cannabis possession, consumption, and their making of these products that provide them benefit to health.
Could I take you back to your arbitrariness point just for a second?
Absolutely.
The way you presented the point orally, at least as I understood it was premised on the patient having or being eligible for an authority to possess, and that the irrationality resided in the fact that you had legal authority to possess the compound, but not in different forms.
Yes.
So I want to know whether your arbitrariness point is premised on a patient who is otherwise entitled to the authority to possess.
We did not challenge at trial the gatekeeper provisions in the MMAR requiring physician approval before one became a lawful possessor of dried marijuana. That was being challenged at the time in a case called Murnaugh that my friend has referenced. It was decided, at least on evidentiary grounds in Murnaugh, that the physician as gatekeeper problem did not render the defense illusory in the way that the Morgenthaler case described an illusory defense, and so we did not pursue that line of argument either at trial or in the Court of Appeal. So for purposes of this hearing before this court, what we're talking about is patients that are medically qualified as a result of being approved for access to the therapeutic compounds by their physicians.
And in the record in this case, there were 2 and 1 pending.
That's correct, 2 and 1 pending, and then further that 5% of the several thousand, 5 to 10% of the several thousand members of the Cannabis Buyers Club of Canada, at least at the time of trial, had been approved for authorizations to possess dried marijuana. Now that number has grown since then, but it is certainly the case that at least 2 of the patients were medically approved by their physicians on the basis of very serious medical conditions that they treated effectively, safely, and without the risk of harms of smoking as a result of having access to forms of marijuana other than dried cannabis. And it's for those reasons that Mr. Smith says the restriction violates the Charter of Rights and Freedoms.
But your remedy seems to me to go well beyond the arbitrariness that you've identified, because you want us to dismantle the regime.
I'm asking this court to read a medical exemption into the Controlled Drugs and Substances Act. If that medical exemption depends for its effectiveness on a physician signing off either under the Narcotic Control Regulation, Section 53,
No,
or other.
We would have to say that the whole regulatory regime is gone, and all that's required is a physician's letter or something of that sort.
I think the Government of Canada has a regulatory regime in place that will govern the production and commercial sale of these products for medical purposes already. What I'm saying is that in respect of patients, they should not be subject to the heavy hand of the criminal law for making the choice to use cannabis in all of its forms. And to the extent that Schedule 2 includes synthetic substances, those were not before the trial judge. Those are not a concern of Mr. Smith. Thank you.
Thank you very much. The court will rise for its morning recess.